plaintiff because you're in a competing market. You're actually in a competing market. And therefore, damages would not have been an adequate remedy at the interim stage. So if we kind of look at 3-4 cases that happened last year, it kind of pretty much gives you an idea as to whether you would be entitled to costs, damages. Now that the court did not want to give us damages, they did want to. I mean, we eventually did get it in the Roche case. But there has to be a way of balancing of factors that, which also includes public interest. I'm not saying it doesn't include public interest. All these have to be taken into account. But in the Merck versus Glenmark, no, it wasn't. So now it's the choice of the plaintiff whether they would want to take it up or not take it up. So,
does Indian patent law provide such a provision of claiming damages by the plaintiff, particularly if patent application gets published in India within 18 months after filing, as by standard, and it can be within 1 month under Section 9, comparatively Form 9, sorry. Is there any damages? And it takes 4 or 5 years for the patent to be examined and granted. During that time, if a infringer, accused infringer, starts practicing a claim of a application, not a grant, patent application, which eventually after 4 or 5 years, if it gets granted, don't you think the defendant takes that interim period, and assuming that Indian patent law does not provide, and he may not have to pay the damages for that period or something like that? That is some concept which is prevailing.
I think what you're talking about is actually the provisional protection. And when you do talk about provisional protection, let me just make one clarification that provisional protection, mailbox applications are actually exempt. The pharma, in terms of the pharma cases, which have been filed between 1995 to 2005, they're exempt, so they're not even entitled to that. Now, another thing that is an important aspect of provisional protection is you're entitled to damages during that period. But what is the underlying principle against which you would be entitled to damages is that how close is your claim as granted to what was published. So if you have a claim which was extremely broad and what was granted is very different from what was filed, I feel that a plaintiff might not be entitled to the damages for that period unless they can establish that they may not be identical, but they're similar in scope. So there are many things that the courts would evaluate when they are determining or assessing damages during the period from publication of an application until the grant or until the grant of the patent.
Okay. Anybody else?
Hi. So, my name is Ashish and I represent ED Consultants. My question is to Mr. Martin. Sir, according to Federal Circuit decision in IPR cases, we can take a broadest reasonable interpretation. So that increases the chances of success of filing IPR cases. So my question is, still some of the clients opt for filing litigation cases in district courts. Is there any specific reason for filing litigation over IPR cases?
In terms of attacking the validity in post-grant review as opposed to in the district court?
Oh, and repeat that, yeah.
Yeah, I mean, there are a number of reasons why defendants have chosen to file in the PTAB in a post-grant proceeding as opposed to dealing with validity in district court. One of the main drivers, I think, is the cost. The cost is quite a bit less than having to fight in district court. One of the other main drivers is the time period. So, and it depends on what district court you're in, but for the most part, you don't have a good sense of certainty as to when you're going to get a decision from the district court or when you're going to get a trial. But in the PTAB, in the post-grant proceeding, by law, they have to decide your case within a statutory period of time, which ends up being about 18 months from when the petition is filed. So I think those are the two two main reasons, and then the third may be that the claim construction, broadest reasonable interpretation, can have a benefit to the challenger of patent validity over what the standard is in district court. And the last reason may be that you can get kind of a second bite at the apple, because even if you fail in the district court, in the post-grant proceeding, and there is some estoppel associated with that, you can still bring other invalidity defenses in the district court once that case picks up again.
My second question is to Mr. Stephen. Sir, my question is related to unitary patents. So suppose there is one client which operates in Germany, and one unitary patent is valid in 3-4 geographies at the same time. So my client wants to evaluate patent in Germany only because he is selling that product in Germany. Would that client be filing the litigation motion in Germany, or is there any different entity that handles the litigation cases for unitary patents here in Europe?
I'm sorry, I didn't quite catch the point.
So my question is related to litigation of unitary patents, UPS. Unitary patents.
Well, if you have a position where your interest is specifically in a national court, in one national jurisdiction, then I think there are certainly if that jurisdiction is one of the more those jurisdictions where there's a strong traditional patent litigation, such as Germany or maybe the Netherlands or the UK, then there are some real benefits in seeking to take the national approach, where you have an established position in terms of the approach that judges might have. If, for example, you have a chemical case, then with the split of the UPC between the three courts being based on subject matter, and that would then go to London, then that would be a consideration as compared to, for example, if you wish to, if there's an infringement issue in Germany. So that also comes back to questions related to filing strategies, or whether there will be a good reason for filing national applications together with European applications. That's certainly something that some of our clients have been looking at doing. We increasingly been looking at filing national applications. I think the other factor as well is that you in relation to costs, if you have a procedure that you're familiar with, that's one less uncertainty that you might be sort of faced with, and so I think it does come down to the specifics, but it's the timing and the cost and the certainty of understanding what the procedure is and what the likely outcomes are that would allow you to make decisions which way to go. Thank you.
Hi, I'm Krishna Gandhi, and my question is for Mr. Martin. Seeing what you've been seeing over the last year and a half, post-Alice, any decisions with the IPAB or the Federal Circuit or the Supreme Court, sitting in your shoes as a litigator, what would your advice be to folks such as myself who advise software companies with preparing and filing software applications, primarily in the mobile application space? Do you have any tips, off the top of your head, any drafting tips that you would know would pass muster with respect to 101 and getting over the hump with Alice?
Well, there's a couple of issues. One is making sure that you're focusing on explaining the invention and the development of the invention and the story of the invention from a technical standpoint. So explaining the problem that the inventors were faced with when they were coming up with a solution to a technical problem, and characterizing it as an improvement in computer technology has been a key to. There's one Federal Circuit case which is very favorable, where they found subject matter eligibility And the reason they did is because they said the improvement was, they called it rooted in computer technology. And so we've used that, and the examiners have been receptive to that type of an argument. So when you're writing your patent application, in terms of the subject matter you want to put in the specification, you want to explain it in terms of a technical problem and your invention being a solution to the problem. The second thing I'll mention is, I mentioned before, these examples. And the examples, by the way, are taken right from Federal Circuit and Supreme Court decisions, where the court has actually said these claims are patent eligible, these claims are not patent eligible, and then the Patent Office made some changes to those claims so that they could have some comparative examples saying this one works, this one doesn't work. So looking at the examples in the guidelines and having at least a set of claims that sort of track the format and the style that is in those examples is really helpful. Because the examiners, and I don't know about in the India Patent Office or even in Europe, but the examiners in the US have a very, very limited amount of time to examine your case and do a search. And 101, at least if I think I know what they're doing, they're looking at the claim and they're probably going right to the guidelines and looking to see if they can get an answer very quickly. And so if they see something that looks like a claim structure or format in the guidelines, you're going to increase your chances of getting the case allowed. And then the last thing is, after you've written it and you filed it, I would encourage you or your counsel to call the patent examiner as soon as you can to talk about it. The examiner won't talk to you until the case is put on his or her docket and it's up for examination. But I can't tell you how much progress can be made just by having a telephone conversation with the examiner, as opposed to getting into called a letter writing campaign, or a back and forth and back and forth and back and forth. And time goes by, and it's not cost effective. But if you can have a conversation, what I found now is a lot of the examiners will give you suggestions, and there's nothing they like more than you agreeing with them. Thank you so much for your suggestion. We're going to amend the claims, and then they're happy and you're happy to get the case allowed. So those 3 points I think are paramount.
I think we will take this as the last questions.
Okay, hi, this is also for Martin, kind of follow-up question you've probably answered previously. In terms of parallel proceedings in the Patent Office, PTAB, and District Court, they both end up at the Federal Circuit on appeal. Now, in Fresenius' case, Federal Circuit said whoever gets there first gets sort of the binding decision. So, kind of the other one would be, and also the fact that if it didn't get to, it didn't reach the Federal Circuit, I think there was a Ford Motor case last year, or year before, where you couldn't bring in the result of the Patent Office into the District Court.
Right.
So what would be your practice tip for somebody, for maybe the patent owner who wants to validate his patent, that Patent Office standards being a little more favorable to him, perhaps Eastern District of Texas being a little more favorable to him, well, how could they go? The speed now seems to be another factor to consider.
Well, in terms of for the patent owner, your options are, I guess, somewhat limited in terms of affirmatively trying to affect the validity of your patent, or prove the validity of your patent. One thing in terms of the district court and the post-grant proceeding is there's a year timer from when a company is served with a complaint within which they can challenge the validity of the patent in a post-grant proceeding, in an IPR. And so, that can diffuse the issue of having these inconsistent or parallel proceedings going on where you may get inconsistent results. But I think until we get some guidance from the Federal Circuit and probably the Supreme Court, it's not going to be necessarily clear when you have sort of this race between a district court case and a post-grant proceeding all going on at the same time, which case is going to prevail. Even if you get, so there's something called the final judgment rule. And in the case I had, for example, we wanted the patent office proceeding to go as slow as possible. The other side wanted it to go as fast as possible. We wanted the district court case to go as fast as possible, and they wanted it to go as slow as possible. So it was like they were doing everything they could to slow down, to speed up the PTAB proceeding and slow down the district court. We were doing the opposite. And I can't believe that, you know, the courts and the PTAB, which are both busy, really want to be dealing with that. So I think there is going to be some guidance that we get as to when a patent office decision becomes binding, you know, invalidating the patent, and therefore stops the district court case, or vice versa. But I wish I had a better answer to give you, but you know, we really don't know at this point.
Thank you very much. I think we are pretty much in time. We started late, we ended late. Thank you very much.
Yeah, across the world.